Hi, Frank Gray from the law firm of Gemetto & Gray, here today to talk to you about how to divorce, specifically the top mistakes we see people making in their divorce papers. As always, if you're watching this video on YouTube, make sure to like the video, subscribe to the channel, hit the notification bell so you know when we're pushing out more family law content to help you with your family law problems. All right, how to divorce. More specifically, the problems that we see all the time when people come in with their own paperwork. I used to be a stand-in examiner for the circuit court. It means I used to do the hearings for the judges. Over the years that I did it, I did literally thousands of divorce cases, and I used to see a few common mistakes that people were making. So I want to share those mistakes with you. Number one, the number one mistake people make when filling out divorce paperwork themselves is not asking for everything. Now, what does that mean? In order for the court to give you something, you have to ask for it. So if you don't ask for it, the court can't give it to you. Sometimes what happens is when people first start the divorce process, they figure, well, I'm going to play nice, my spouse is playing nice, and then at some point things go sideways and everyone's not playing nice. And the original spouse says, well, I want what I said I wasn't going to originally ask for. And they come into the final hearing and they ask for something from the judge that they haven't asked for in their pleadings. And the response is always the same. I can't give you what you didn't ask for. So you have to ask for everything up front. It's always easier to say I don't want it than to say I want it, but I didn't ask for it. Common mistake number two, I'm going to call it not having a plan, but what it really means is people weren't drilled in on their cause of action. I'm going to throw a link in the description down below to a video I did specifically on causes of action where I go into each of these causes of action in depth. But in order to get an absolute divorce in Maryland, remember, you have to have a reason to get divorced. There's nothing worse for both you and for the court than going through an entire divorce trial only for a judge to say, well, my goodness, it sounds like everybody wants a divorce, but you don't qualify for a cause of action. You haven't proven the reason for a divorce. That can be not just a big waste of time, but it can be really irritating for everyone. Plan ahead. Make sure you have a cause of action that you can prove for your divorce. The first two problems I've given you generally relate to the plaintiffs. That means the person who files the initial lawsuit. The one I'm going to give you now, and my third most common mistake, is going to apply to the responding party, probably the defendant. What happens is people are served with paperwork and they don't read the papers. So they do one of two things. They either don't file an answer, which means they end up in default, which basically means the case goes on without you and you're not going to get the relief you're asking for. Or they just file an answer without actually doing it the right way, without admitting or denying every numbered paragraph. They're not admitting or denying the facts. They're not asking for any relief for themselves. They're just filing something seemingly for the sake of filing it that doesn't get them anywhere. And then in the end, when you're there for your merits hearing and a judge takes a look at the file, they say to the defendant, my goodness, you haven't really asked for anything. How can I give you anything when you haven't asked for it? I don't think you read the paperwork. The plaintiff is asking for a bunch of things. You didn't tell me whether that's something you agree with or disagree with. You haven't told me what you want to see happen. So again, this is on both ends of the spectrum, both for the plaintiff and the defendant. Make sure to read the paperwork that you're served with. Before you go, I want to mention there are alternatives to a traditional contested divorce, such as mediation. As someone who's seen literally thousands of families going through this process, I can tell you that as an alternative to a contested divorce, mediation is going to be a much faster, much less expensive process that is going to give you much more control over your family than allowing a court to decide it in a traditional contested divorce. Not all cases are right for mediation, but if you're here looking for information, definitely think about mediation and look to see whether or not it might be right for you and your family. I'm going to throw a link to a bunch of mediation videos that we've done down below for you to explore. I'll also throw the link to our family book that's going to give you a lot of information about general family law topics.